Thank you for joining us at our Prestige PEO webinar series. My name is Carrie Kaiser, and I'm Marketing Operations at Prestige PEO and your host this morning. Today's webinar will cover compliance updates on the Southeast Coast. Joining me today are Carrie Pilon and Megan Siegel from the Prestige PEO Compliance Department. Our webinar audience members are muted by default. However, we encourage you to make the use out of our chat feature to pose any questions you may have. We will respond to them towards the end of the webinar, time permitting. If we are unable to get to your question, we will reach out to you shortly after the webinar concludes. Additionally, the webinar is being recorded and will be made available on our website at prestigepeo.com/webinars. You can also take a look at the latest compliance alerts in our Compliance Center at prestigepeo.com/compliance-updates. And now we'll get started with the webinar. Welcome, Megan and Carrie.
Good morning.
Good morning. Thank you, Carrie. So we're going to get started with some federal law updates here. And Carrie, why don't you take us away?
All right. Good morning, Megan. Good morning to everyone. And thank you again for joining us today. First up, we have our overtime rule update. The Department of Labor, as we know, last updated the overtime exemption threshold back in 2020. So we wanted to kick things off this morning with just an alert to everyone that late last year, the Department of Labor unveiled a new proposed rule, which is slated for an anticipated April of 2024 release date, defining the new white-collar exemptions from overtime and minimum wage requirements under the Fair Labor Standards Act. As you can see from the slide, the proposed rule sharply increases the minimum salary requirements or thresholds for the executive, administrative, and professional, or the EAP, exemptions to apply. These thresholds would increase from that $684 per week, or $35,568 $100 per year, rather, to $1,059 per week, or that $55,068 per year, which is a 55% increase from the current level. The minimum salary for application for the highly compensated employees would jump by 34%, or from $107,434 to $143,988 per year. The proposed rule also has a built-in mechanism to periodically increase the threshold moving forward, which I believe is every 3 years. And as mentioned, it's slated for an April of 2024 release and would go into effect 60 days after the final rule. It's also important for our clients and employers to understand that some states, such as California and New York, already have a higher minimum salary threshold for exempt employees. So it's important to keep these two different regulations in mind when we're looking at compensation and job descriptions. So in addition to that, the actual salary threshold will be based on the earnings data of the date of the final release, rule takes effect, rather, the release date, which means the salary floor may actually be higher than the projected $55,068. So again, just something to keep in mind. Thanks, Megan.
Yeah, of course. So next, another update at the federal level is the Department of Labor has an updated version of its independent contractor rule. As many of us on this webinar already know, there are multiple different agencies with multiple different tests for how to determine an independent contractor. So this rule from the Department of Labor will be effective on March 11th of this year, and it restores the totality of the circumstances analysis of the 6 factors listed here on the slide. I'm not going to bore you by reading all of them off, but it mostly comes down to the level of control over the individual. The more control and the more direction you're giving to an individual performing a job or a task, the more likely the Department of Labor will see them as an employee versus an independent contractor. And when determining if your own person you're hiring is a true independent contractor or an employee, it's always a good reminder to take a look at the DOL standard as well as the IRS and a few of the other independent agencies that have one out there.
Next up, we want to make everyone aware that there has been a partnership among agencies. Specifically, there was a memorandum of understanding that was signed by agency officials back in September of 2023 between the Department of Labor and the EEOC. They have entered into an agreement to collaborate and share information with the intention of improving both agencies' enforcement efforts. So that it's declared that by forming this partnership to encourage greater coordination between them through information sharing, joint investigations, training, and outreach, they're trying to better streamline the processes between the two agencies. But effectively, the key takeaway from this is that some typical Department of Labor audits and investigations could potentially lead to investigations by the EEOC under, for example, an Equal Pay Act or Title VII of the Civil Rights Act or Title I of the Americans with Disabilities Act. So it's going to include that information sharing regarding suspected violations, as well as advising the employee who brought the initial charge, say to one agency or the other, or the complaint, that they may be able to file a charge or a complaint with the other agency. I think this, Megan, also signifies greatly that the agencies are gearing up for more enforcement activity, certainly.
Yes, and I think, building off of that, Carrie, it's a good reminder to everyone that these federal agencies do ebb and flow with the political climate of Washington. So it is a good reminder that while this might be everything right now this year, these could all change again in 2025 or later, because a lot of these agencies will have a set term for people that can be on them at the decision-making level, and it will really mirror what's happening within the federal government. So just a good reminder for everyone.
And it is an election year, certainly.
Yeah.
All right. We also have some additional guidance here under what's called the PUMP Act. As we know, the PUMP Act was adopted along with the Pregnant Workers Fairness Act in December of 2022. So keeping in mind that this regulation has already been enacted, the Department of Labor has finally issued internal guidance for agencies officials responsible for enforcing the PUMP at Work provisions, including those enacted under the 2022 providing what's called the Providing Urgent Maternal Protections for Nursing Mothers Act, or what we call the PUMP Act. So these guidelines really do provide a glimpse into how they will be enforcing the PUMP Act. And just as a reminder, under the PUMP Act, it requires employers to avail their employees of a reasonable break time in place to express breast milk at work for a year after the child's birth. And again, it does get into some of the details here. They're also required to provide employees breaks every time they need to pump. The length and frequency of breaks will vary by employee. And although the employee and the employer may agree to a schedule based on the employee's need to pump, the actual agency advises employers that they cannot require an employee to comply with a fixed schedule. In other words, the need may change based upon the employee. And time for pump breaks may be unpaid unless otherwise required by federal, state, and again, that local law. So you may have different provisions in different parts of the country or different areas of your state that require this time to be paid versus unpaid.
Some new updates in the COVID side of things. The CDC has been contemplating to drop its isolation guideline for those who contract COVID-19. As of now, the guidance is to stay home for at least that 5-day, incubation period, so that the spread is limited. But the CDC coming up possibly in April is similar to other general illnesses where the shift for testing positive is not necessarily the standard. It would be based on symptoms. So if you are fever-free and you have mild symptoms, that might still allow you to go back to work based on the CDC guidance. Again, this is still a few months away from them releasing what is their official new guidance, but something to keep in mind when working on some of those PTO policies. All right, so next we have the NLRB Joint Employer Rule. So we're definitely seeing at the federal level an increase in employee rights and wanting to make sure that employees are receiving all of the benefits that they are otherwise entitled to. So the NLRB issued this new joint employer rule which will be going into effect in just a few days. And the NLRB is very employee-friendly, even depending on political climate, tends to be the one agency that's most employee-friendly. And this new rule will replace what was there in 2020. And it primarily impacts employers that are franchisors or franchisees, but it does have a huge impact to all employers. So with this new rule, an entity may be considered a joint employer of a group of employees if each entity has an employment relationship with the employees and they share or co-determine one or more of the employee's essential terms and conditions of employment. So again, this all comes down to, similar to the independent contractor rule, control. Who is controlling the day-to-day of this employee? Who is making the decision on hiring and firing? Who's determining what their salary is? That is going to be those, key factors, and there are 7 that this new rule does explicitly list out, and those are on the screen. But again, it comes down to control and who is making ultimately those decisions. And the NLRB was kind enough to release a fact sheet. Not everybody does this off the start of it. And so we can certainly get that over to everybody on this webinar this morning, later today or this week. I'm not sure when that'll be sent out, but we can certainly get it over to you. All right, so now jumping away from some of the agencies, we have some case law updates for everybody. And this is going to be some federal law case law updates. So for Muldrow v. City of St. Louis, so this case really comes down to the ultimate question of, is a lateral move considered on its face a significant disadvantage in relation to a discrimination lawsuit? So a brief synopsis of the facts here is there was a woman who was in one position, and she was then voluntold, would be the best way to consider it, that she would be now in a new position that changed her hours, it changed her uniform requirement and everything like that, but her pay was the same, and it was still the same, level title-wise, and it was ultimately just a lateral movement. And she filed a discrimination claim. So now, based on that, the Supreme Court is taking a look at that case. The case history, briefly, is on the slide. And this decision will likely be released June of this year. And this will really, depending on which way the court goes here, really impact employers, where previously you would have had to show that there was additional harm in, that type of discrimination case with a lateral, job movement. But now on its face, pending how the court goes, a lateral movement can be seen as a harm. We're not there quite yet, and we'll see how the Supreme Court goes here. But just something to keep an eye on for us, and we will certainly update everyone once the Supreme Court makes some of its decisions in June.
Absolutely, absolutely. There's another case that has recently come to the federal level, which was the Eisenhower versus the Culinary Institute of America. This case in particular was a recent federal case that involved a female instructor at the Culinary Institute of America who had been there for quite a while. She had alleged a pattern of pay disparity over the course of about a decade and a half. So I think it was about 13 to 14 years between her and a similarly situated male colleague. And here you can see it was a federal case about both the Federal Equal Pay Act as well as New York's Equal Pay Act. So again, it's alleged the plaintiff alleged the employer violated both of these laws. And the Federal Equal Pay Act allows for an unequal pay if it's based on any other factor other than sex. But the New York law, Megan, it's much stronger, and it adds that additional requirement that the factor other than sex must be job related for the position in question. So while the defendant, the Culinary Institute of America, did prevail under the federal EPA, the appellate court clarified that these statutes were very different, and they remanded the matter back to the state court under New York's Equal Pay Act, which had, again, that stronger, higher standard. So again, even though this is a New York case, it's important to highlight that oftentimes state laws are more protective for employees than federal laws. And again, as an employer, it's important to remain vigilant to the multiple layers of regulation when it comes to these types of issues. So.
And now, on that note, we will move into some more state-specific updates here.
Okay.
So thank you, Carrie. All righty. So we're going to start off in Virginia, in our southern states here. So last year, a bill was signed that will eliminate over time the sub-minimum wage for individuals with disabilities within the state of Virginia. It does have one exception to it, sort of a grandfather clause, if you will. And so employers will now be required to pay individuals with disabilities the standard minimum wage rate under the Virginia Wage Act. And that exception applies to those employees, that grandfathered in portion, that employed individuals with disabilities prior to July 1, 2023. And those employers are still authorized to pay the sub-minimum wage to those employees under that FLSA certificate exemption that this law allows. And this exemption will remain in effect until 2030. So several years for that exception for those employers with existing employees. But moving forward in the state of Virginia, they're really phasing out that sub-minimum wage. And so for new hires, anyone that doesn't qualify for that exception, will be required to pay the standard minimum wage rate under that new Virginia law.
Thank you, Megan. Moving into Alabama, we have an interesting highlight here for employers, which is a temporary tax exemption regarding no withholding for overtime. Now, what this specifically is talking to is the Alabama tax code, which has been temporarily modified to provide that all overtime pay received by full-time hourly wage paid employees for hours worked over 40 hours in a work week are excluded from gross income and are exempt from the Alabama state income tax and not subject to withholding. The exemptions will not apply to salaried exempt employees or those employees or workers paid under alternative pay methods, but commissions and bonuses in addition to the hourly wage, again, are not exempt. Only hours actually worked will qualify. And again, it's temporary. So this is a temporary tax exemption that applies for the tax years beginning this year, so January 1 through June 30th of 2025. But again, it's state income tax only. This has no federal provisions in it. And then next up, we have North Carolina. We're going to move over to the Tar Heel State. North Carolina has been active, really busy in their last General Assembly when passing their general budget. And we found in September of 2023, the North Carolina General Assembly included in this most recent budget a prohibition against any local ordinances adopted by county or municipalities that establish a minimum wage, an overtime, or leave laws that are different from the State Wage and Hour Act. So we found that in a lot of different municipalities, local governments have chosen in different states to pass their own minimum wage laws, their own overtime laws, really what in the state of Florida is called home rule. The North Carolina General Assembly, again, has said no regarding any local ordinances that are affecting either minimum wage, overtime, or leave laws. They're going to be precluded from this budget period, and that budget period runs from October 2nd of 2023 until June 30th of 2025. So again, any such wage and hour ordinances that are adopted will no longer be allowed effectively at the state level. So you have to follow the state level guidance. Another change that we've identified was North Carolina several years ago, I think back in the 1970s, effectively instituted their own OSHA. So they have their own North Carolina Department of Labor and, their own North Carolina Occupational Safety and Hazard Agency, I should say. And in October of 2023, the Department of Labor has now changed the ruling so that the North Carolina OSHA will only have 6 months following the occurrence of any violation to issue a citation to employers. So with this modification, it's important to understand that prior to this, the North Carolina Department of Labor was also authorized to cite violations that occurred at any previous time, so long as the citation was issued within 6 months following the initiation of the inspection. So any violation that the Department of Labor, they could have gone back to the 1970s when this was instituted, and as long as they provided that violation citation to the employer within 6 months after the inspection began, they were still in compliance. So that has now changed. So this is really kind of a employer-friendly type of change, where now employers are only subjected to the 6 months following the violation to be cited. So again, another change in North Carolina.
Yeah, so now employers in North Carolina don't have, that looming in the background potential for some liability. So this is definitely a change that employers in North Carolina should be welcoming.
Exactly, that's definitely
we'll now move.
Really got shortened up. Exactly.
Well, we're now going to move into South Carolina and talk a little bit about notice of wage deductions. So this, again, is going to be South Carolina specific. Every state will treat wage deductions a bit differently. So a recent court ruling in South Carolina ruled that under the South Carolina Payment of Wages Act, it does not require an employer to provide detailed advance notice of the amount of wage deduction to satisfy the requirement under the statute, but it does allow for a reference to the potential for deduction, and that notice that, we don't know what the deduction amount will be, but this may be subject to a deduction later on. So this case specifically was a registered nurse who signed the wage deduction policy of the hospital where she was working. She was then, at some point, subsequently terminated, and she had some outstanding medical bills. And since it was with that hospital, and within the wage deduction policy, her prior employer deducted those wages from her final paycheck.
Right.
And that's what led to this case, and where the court did hold that generic notice that she received at the time of her hire was sufficient under South Carolina's laws.
Again, I think another kind of employer-friendly ruling, if you will. Definitely.
Yes, I would agree with that too, Carrie.
And I think part of the court said,
Alrighty.
part of the ruling the court said on that too was that we really don't know the termination dates, right? We don't go into employment with an idea of when the termination date will happen. So the employer really is held to a higher standard if they can't issue that generic wage deduction notice versus, having to provide the specific information, which of course at the time of hire is unknown. So again.
Alrighty. So moving down to Georgia, we have some updates in the non-solicitation realm. And this non-solicitation and non-competes are right now a hot topic across the country. But Georgia specifically is focused this time around on the non-solicitation piece. And so the non-solicitation provision in either a contract or a separate agreement is a tool for employers to use to prevent its former employees from recruiting current employees of a company. And so now what Georgia courts have ruled is that those non-solicitation provisions must have territorial limitations to be enforceable. So really what that means is you can't prevent someone from working across the state of Georgia. It is a huge, or from pulling people from Atlanta to, I'm not as familiar with cities in Georgia, but to somewhere closer to down to Florida. And that restriction is really so that it still allows for movement should people want to leave a company and still make that balance between employers and employees. And then based on this law, just a little cherry on top here for Georgia is that those independent contractors would be considered employees in this capacity, and employers should keep in mind non-solicitation agreements with those territorial limitations when contracting with those independent contractors. All right, Georgia's got a lot going on right now. So next, similar to some other states in the north, Georgia has its employee voting leave law. And this time around, back last July, they amended it to allow employees to have 2 hours of unpaid time off on election day or an early voting day, depending on when that's designated in the state of Georgia, to vote in primaries and other elections across the state. And the big change here is those early voting days. Prior, the laws did not allow for that, and now it does. So employers should really keep this in mind when, especially now that we are in an election year, that if an employee does make this request, to really work with your employees so that you are not found in violation. And the next change is the employee sick leave law to care for family members. Again, this is a trend we're seeing across multiple states. And in Georgia, this law is here to stay. As of last July, what was previously a temporary law to kind of see how it worked in the state became permanent. And so this law officially requires employers who offer paid sick leave to allow employees to use up to 5 paid sick days to care for their immediate family members. And the state will define what they consider immediate family members, but the trend is, you know, spouse, children, adopted children, et cetera. Every state does have a little bit of difference in how they define a family member, but generally those are the ones that are the same across all.
Okay. Moving down to Florida. Florida has new COVID-19 related restrictions. So under this new legislation, it broadens the restrictions on businesses based on individuals' COVID-19 related decisions. So employers cannot require any person to provide proof of vaccine status or to submit to a COVID-19 test in order to enter, access, or receive services from a business. Employers are also prohibited from requiring any person to wear a face mask or other facial coverings extending over the nose and mouth, with limited exceptions, that including healthcare provisions. And again, employers cannot hire, fire, or otherwise make employment decisions based on employees or applicants' COVID-19 vaccination or post-infection recovery status, or that refusal to take the COVID-19 test. And it's important for employers to understand that if they fail to comply with these new rules, they do face hefty administrative fines, up to $5,000 per violation. And if the situation revolves around terminating an employee, the employer may be ordered to reinstate the employee. So.
Yes, and I know this is a bit of a different trend than some of our northern states. So if anyone is listening on those webinars, Florida is taking a vastly different stance than many states across the country. Alrighty, so moving over to Louisiana and to Act number 210. So interesting, coming out of Louisiana is this act, which is an amendment to the Louisiana Employment Discrimination Law. And so this act allows for employees to receive a 1-day unpaid leave for genetic testing or preventative cancer screenings. If, you know, for employers, this is an unpaid leave. But if an employee has their vacation or PTO time and they request to use it for that day, then employers must allow the employee to use it. If, on the other side of it, if the employee has used all of their vacation or PTO days and they request to have the day off for genetic or preventative cancer screenings, then you are still obligated to allow them that unpaid time off. So for employees to qualify for this leave, an employee must be seeking testing that is medically necessary, and that is very much defined within this act. Didn't want to bore you with a lot of words on the screen, but it's essentially that someone can't just come in and say, oh, I have a medical necessary need to take this day, and then just not show up, not provide any documentation. There is more of a process to this. It does have to qualify, and the employee must provide notice at least 15 days before the date the employee intends to take the leave. And typically, unless, there's a last-minute change in a doctor's availability, typically when you're scheduling out appointments, employees will have at least 15 days notice minimum. And to ensure that they are seeking a test that is medically necessary, an employer may request documentation to prove that that is what this appointment is for and what the employee is going to see their care team for. Employers are not allowed to request documentation of the employee's test results. So if someone, in your office comes to you and says, hi, I have a doctor's appointment on this date for genetic testing. I'm going to need the day off. I don't have any PTO left. You are required to provide them that unpaid leave, and you may ask them, hey, can you just provide, proof of that appointment? Right now, it's still unclear as to what entails proof, but typically it is just a confirmation of that employment from the physician or other care team member.
All right, going up to Washington, D.C. D.C. is moving to be more in line with a lot of other states, particularly out west and up north, with their pay transparency law updates. So there is a Wage Transparency Omnibus Amendment Act of 2023 that amends the D.C. Wage Transparency Act of 2014. This will become effective June 30th of this year, and it's applicable to all employers with at least one employee in Washington, D.C. So at this point, it does require DC employers to disclose the pay range from minimum to maximum potential amounts for each job on all job postings for open positions. This would be disclosed on both public and internal job advertisements. And it also requires employers to disclose the availability of health care benefits prior to an applicant's first interview with the potential employer. So really making that the availability of healthcare benefits known to the applicants prior to their first interview. So again, just moving more in line with several of the other states. It also is prohibited from, employers are prohibited from requesting an applicant's wage history or using an applicant's wage history in the screening process. Employers are also required to post a notice that informs employees of their rights under this law. And of course, no posting has been made available yet, but employers who violate the act may incur fines of anywhere from $1,000 to $20,000 per occurrence. So as soon as we have additional information on the posting notices, it will be something that we will make available.
Yes, and it is definitely a law to not take lightly. Many do exist, but the range of the fines that employers may incur definitely put this one on our radar as an important pay transparency law.
Absolutely, because it does affect, everything from the job posting to the interview process, certainly. And I think that moves us into employment law trends. Mm-hmm.
Yes, it's definitely also a trend. And just one last thing on DC here is that right now, it's very vaguely defined of what entails a job posting. And so they haven't provided additional guidance on that yet. But in other laws, it's typically, anytime you post on a job board, anytime you post on an internal, intranet, anything like that, social media sites that allow you to post information about a job. That one is still a little bit unclear, but hopefully we'll get some more guidance as we move closer to these dates.
Yes, I agree. So again, moving into employment law trends and hot topics for 2024, as Megan and I have been kind of alluding to throughout the case law update as well as the state law update, there's some trends that are kind of sweeping across the nation as a whole. Pay transparency, of course, being one of them, as we just mentioned. So we now know that 25% of U.S. workers are covered by some sort of pay transparency law or regulation, but we're finding that could move closer to about 50%. The states that currently have pay transparency regulations or laws we know include California, Colorado, Connecticut, I believe Maryland, right, Megan? We have New York, Nevada, Rhode Island. We now have DC, and I believe Washington State. So in addition to that, I know several other cities and counties have their own pay transparency requirements. So we really have to kind of keep an eye on this as these regulations not only become legislation, then they become law, and then certainly the enactment date. So the goal for these pay transparencies is certainly to level the playing field with for women and minorities. And so employers should be reviewing their job postings for compliance with applicable state and local, as well as any particular county or state laws as well.
All right. So one that we haven't really touched on quite yet today is data privacy. And this is something that is continuing to be a trend across the country. Right now, the United States does not have a federal, all-encompassing data privacy act, similar to some in Europe, like the GDPR in the UK, or some of the European Union data privacy laws. There are some federal acts that touch on bits and pieces of data privacy, but really it's coming down to that state level. And some that we're seeing now, right, are in California, Connecticut, Colorado, and just a huge trend across the country for, protecting your own data, protecting the data of your employees, how employers and companies are allowed to use the data of their customers, of their partners. It's going to vary by state. While a lot of these laws have common threads with where you must disclose if you are going to be making a profit off of selling data, they do vary vastly based on state, and definitely recommend for employers based on the states that you are in and you have employees in to take a look at your internal processes relating to your company's data and your client's data to ensure that you are in compliance.
And we've noticed also several of these data privacy type of regulations do control the age of the recipient. So the information, whether it's a minor versus an adult. So we're seeing a lot of restrictions involving minor children as well. So just again, something to keep in mind when you're looking at your own internal processes, certainly. Moving over to non-competes. Yeah, I think we've talked a lot about non-competes, but again, just defining them for clarification would be any agreement or clause contained in an agreement between an employee and an employer that restricts the employee from obtaining certain employment after the current employment has ended. So we just highlight here that Bloomberg had an interesting article that cited 44% of New York workplaces use non-competes. And again, I know we're in the Southeast, but just something to keep in mind as these laws do become, these regulations and legislation do become laws, that certain groups are looking for, these exceptions, but they're becoming much more widespread. The tech industry in particular is in favor of this ban. As you can imagine, these tech workers tend to be very, they work all over, and they tend to touch a number of different jurisdictions, if you will. So.
Yes. And then, building on that, this is, a reflection of the change in the workforce and with remote work, and we don't really have those same restrictions that have been in the past, where if someone is living in Atlanta and they move to Tampa, in the past that was considered, so far away, and a non-compete might not otherwise extend that far, south, or not just south, but in any direction. But now increasingly seeing the movement of employees and employers, the increase of remote work, having that those restrictions on employees at the federal and state levels, they're starting to, right, as Carrie mentioned, face this scrutiny. And at the moment on the federal level, the FTC is scheduled to announce its decision on banning non-competes. This is not finalized. Like Carrie mentioned, there was a lot of opposition. So we don't know if what was proposed to finally becoming, legislation is going to mirror it exactly, or if there are going to be some updates with some exceptions or exemptions included. So that is also something we'll be keeping an eye out, since we know it's on the horizon, but don't know exactly what it will be. There are some states that have already significantly limited the use and availability of non-compete clauses, some of those being Colorado, Minnesota, North Dakota, Oklahoma, and California. California, well, again, it's not in the South, has taken a very, very hard stance that all non-competes, whether they are in the state of Florida or California, are completely illegal under their state law, where some other states might only ban them within the state, or some just more restrictions rather than an outright ban. We know that a lot of this comes down to the public policy and that increasing of movement of employees and not wanting to restrict an individual's ability to earn for themselves based on something that developed out of a very, insular job market, where you weren't really moving outside of Miami or Jacksonville or New Orleans, and you were really staying close to that area.
We've also mentioned paid family leave. I know we mentioned we touched on it in the state of Georgia, utilizing your sick leave for provision of taking care of family members. But we are seeing, again, a wider spread range, if you will, of states that are enacting paid family leave laws, and in particular funding the paid family leave provisions through employee and sometimes employer contributions. So again, just something to keep in mind, and employers entering into these new states should carefully review the paid leave family laws of each state for compliance, because again, they are very different from, up in the Northeast, Massachusetts and New York is very different again from areas in the Southeast. So just keeping that in mind, and really kind of planning ahead for that type of, if there is that employee and employer contribution, that we're keeping an eye on that and really notifying employees accordingly.
Yes, and then also not just so some states do call it paid family leave, others call it sick and safe time, and some of those laws may overlap, where some states might be enacting the sick and safe time, and what would also qualify for paid family leave in some states falls under the sick and safe leave laws. But there are other states that have both in place. So that's another trend that we are seeing nationwide as well.
Right.
All righty. Well, thanks for listening to us, everybody. I know Carrie has been monitoring the chat for some questions for us. So when she is ready to give us some of those, we'll start to answer some questions.
Thank you so much, Megan, Carrie. We did have a few questions come in. If we don't get to your questions, we will get back to you. But How about, will Alabama's overtime tax exemption impact federal income taxes?
So I'll take that one, Megan.
Sure.
The temporary tax exemption regarding withholdings for overtime was specific to state income tax. And again, it is temporary in nature. So no, it will not impact the federal provisions. It's only state income tax.
Okay, great. The next one is, what do I, as an employer, if I have employees in multiple states with multiple sick leave and or family leave laws?
Sure, and I can take that one. So that's actually a great question, since we know a lot of our clients do have a presence across the U.S. And there's a few options that employers can go with here. One of those being that for each state that you have an employee in, you have maybe an amendment to your PTO policy or an amendment to your handbook that states within Florida, within Minnesota, whichever state that they're in, they follow those leave laws. And that can get tricky. You're managing, sometimes 3, 4, 5 plus different leave laws. While it's certainly doable, it is a lot to keep track of. And another option would be to take a look at all of the states that your employees are in, taking a look at your own PTO or other sick leave policies, and finding the one that is the one that's most in favor of the employee, the one that gives the most days, and adopting that as your company-wide policy, unless your company policy is already exceeding what is required by that state, affording the employees their most time off and most coverage. So those are two different ways that employers can tackle that one.
Okay, great, thank you. And then one more here. In the light of the new threshold minimum for overtime exemptions, can an employer refuse to pay overtime?
Carrie, you want to take that one?
No. The employers, which are covered by the Fair Labor Standards Act, are always required to pay the applicable minimum overtime requirements to non-exempt employees. So the distinction here is the exempt versus non-exempt. And that would be for all hours worked over the 40, keeping in mind that even if it's not authorized, you still have to pay it, of course. So that threshold, the new upcoming threshold, is certainly something to keep in mind. But more importantly, I think it falls back on, do you have an appropriate policy in place that would either prohibit the overtime or allow for an employer to potentially discipline for the overtime, but in no way are you allowed to not pay for overtime work that has been paid. Again, and I know the fines can be substantial. The risk in not paying would be, back wages, fines, possibly legal fees, the employee's legal fees, and the DOL, I believe the fine can be very substantial as well, up to $1,000 or more, depending upon the state laws. And again, you're looking at both state and federal regulations with this one. So.
And the other, potential off of that would be additional audits if it's something that the Department of Labor, whether it's in your state or at the federal level, is seeing as consistent mismanagement or consistent violations, that might also subject employers to audits that they do not want to be a part of.
I think Megan, you just touched on something incredibly important. It does often trigger those audits. It's almost an automatic trigger. So yes.
All right, great. Thank you so much, ladies. And thank you for this insightful presentation, and to everyone who joined us today. The recording of this webinar is available on our website at prestigepeo.com/webinars. If you have any further questions, feel free to reach out to your HRBP for further assistance. Stay updated on compliance alerts by visiting our Compliance Center at prestigepeo.com/compliance-updates. And don't forget to check your inbox for our monthly Insights newsletter, delivering the latest HR news. Connect with us on Facebook, LinkedIn, Instagram, and Twitter for the latest information at Prestige PEO. And lastly, don't miss out on our Prestige Go mobile app, which provides access to benefits information and on-the-go support from your HR team. Thank you all, and we look forward to seeing you next time.